Hi guys, welcome back to 12 Minutes to Clad. This is Keshav Malpani. And if I ask you that what is the most frequently used app, or in fact the most used app in your smartphones, I think most of our answer would be same, that it's WhatsApp. Okay, we rely on WhatsApp and it becomes so indispensable to our lives these days that we rely it on for normal conversations, for sharing media, pictures, videos, and so on, right? It's very important for all of us to be on part of WhatsApp because it has certain important information also that we get because we're part of various important groups as well. You won't believe that in the entire world there are more than 2 billion users of WhatsApp, out of which 400 million exist in India itself. Okay, so India is a great industry. In fact, there's a huge market for WhatsApp at this point in time, and it's growing exponentially every year. So today we're going to discuss about the WhatsApp's new privacy policy that actually created a lot of controversy around the country. We're also going to discuss about WhatsApp's recent dispute with the government of India and the reason for that dispute. So we'll understand it in detail, these two topics, in this particular session. So WhatsApp in January starting this year in 2021 came up with this new privacy policy wherein WhatsApp asked each and every one of its users to actually agree to this policy, basically give their consent to this policy. And if the users do not give their consent to this policy, then certain I would say applications of WhatsApp or certain operations that you could do in WhatsApp will be hindered. Okay, your account won't be deleted, but then you won't be able to use WhatsApp at its 100% capacity. There will be certain issues with it. Now let's understand as to what were the salient features of this privacy policy. The first and the most important feature was that it required consents of the users to share transaction data, mobile device info, IP address, and data on how they interact with business. And then this data would be used to be shared with the WhatsApp's parent company, which is Facebook. So it also allows WhatsApp and Facebook to share that information with third party providers also. Other than that, there was certain information which included our phone numbers, our locational data, basically our login information, that was to be consented to be given to WhatsApp. Now people felt at that time that this is a clear violation of their privacy, because earlier this policy was to be, everybody had to agree to this policy by the end of January and sometime in February. Although due to a lot of controversy, WhatsApp increased the timeline, but basically extended the timeline, and timeline came to the last date was 15th May 2021. Okay, that was given as the last date by WhatsApp. However, after that also WhatsApp released a clarification wherein it said that even if people have not agreed to that policy, their account will not be dismissed. Basically, their account will not be cancelled. Their account will still be there, but there is a possibility that the usage of that account may become limited because there are certain applications of WhatsApp, and as I already told you, certain operations of WhatsApp that may not work with full capacity. Now, why was it so controversial is something we need to understand. Okay, so if you remember, there was this 27 Supreme Court judgment. There was a 9-bench judgment called KS Puttasamy versus Union of India. KS Puttasamy versus Union of India clearly stated that right to privacy is a fundamental right of each and every individual, and the government can take away this right from a person only in 3 circumstances. The first circumstance was that when the government takes the right, there should be a legitimate aim, there should be proportionality in which the right is being taken, and the way in which it is taken, there should be legality attached to it. Okay, so basically it said that only in extreme circumstances where there are certain national security issues or issues that is actually public order issues wherein sometimes some kind of violence has been spread, things like these, then only the government can take certain actions and hinder on the privacy of the people. Otherwise it cannot do so. Okay, so it was a 9-judge bench judgment of the Supreme Court of India in 2017 which clearly stated that right to privacy is a fundamental right under Article 21 of the Indian Constitution. Another major issue here was that India does not have a data protection law as such. Okay, so a lot of people thought, in fact the critics thought, that if this particular data that WhatsApp is taking from us and distributing with third parties also, if that data is leaked, then what happens? What is the recourse that we have as Indians? Okay, we do not have a recourse because we do not have a data protection law. We have a data protection bill of 2019 that is still pending in the parliament, and nobody knows as to when that bill is going to be passed. So that was another major concern with respect to this particular privacy policy that WhatsApp released. Okay, we saw what the controversy happened in Arogya Setu. I made a full video. So it was the same privacy issues that a lot of critics had because they did not want to share their data with the third party, and they did not want them to, their data to be in public domain as such. So So this was the major issue, and that is why there was so much controversy around the entire privacy policy that WhatsApp came up with. After this, what happened in February 2021 was the government of India came up with this new set of regulations called the Information Technology Intermediary Guidelines and Digital Media Ethics Code Rules 2021, जिसको IT Rules 2021 कहा जाता है. Now what these rules said was that this rule basically talked about two kinds of platforms. One was the OTT platform, which is the over the top platform, that is the application that we use like Netflix, Amazon Prime, Sony Live and so on, and other social media platforms which is more than 50 lakh subscribers, okay, or more than 5 million subscribers, which includes WhatsApp, Twitter, Instagram and so on. Okay, so these were covered. Why were these covered, and what was the basic reason to covering these particular social media and OTT platform was that there was a lot of hateful information that was being circulated on this. Hateful information, we can say it was certain false information that were being circulated, and due to this the government felt that there were certain national security issues that were created. So in order to curb that, the government brought certain set of guidelines wherein every such organization which is the OTT platform or the social media platforms need to have a grievance officer. They also had to agree to something called the traceability clause, and that is a major cause of concern here. Okay, traceability clause means that if the government wants the social media platform to reveal the name of persons who actually started a particular message which say became hateful or against the government or things like these, then it is the duty of the social media platform to provide such names to the government of India. Now this created a problem, and WhatsApp said that this is a violation of the fundamental rights of people and in fact violation of human rights. So what it did was on 25th May 2021, which was the last day of complying with this particular guidelines, it filed a case against the government of India in the Delhi High Court. It stated that if traceability clause is applied and if it is kept, then it hinders to WhatsApp's end-to-end encryption policy. We know what end-to-end encryption is, right? It means that all the messages that we receive and that we send are only between the sender and the receiver, and even WhatsApp cannot read those messages. That is what it claims basically. So that is the end-to-end encryption policy. Now the WhatsApp's argument is that if we are allowed, basically if we are compelled to share these information with the government authorities, then it violates our policy of end-to-end encryption, and it also violates the fundamental rights of the citizens of India, because right to privacy is a fundamental right as per KS Puttasamy judgment. The WhatsApp also stated that if these guidelines are implemented as it is with the traceability clause, then there are certain innocent people who may be unnecessarily implicated, which means that they may become a part of the investigation unnecessarily, even if they had actually spread this information out of concern, just to tell people that this is something wrong happening and all of that. Then also they may be part of the investigation, and they may have to go under a lot of hustle. That is another concern here. In fact, WhatsApp released a memo on 25th May and made it very clear that it has a separate department which works 24/7 assisting the government authorities if there is any information wherein somebody's life is in danger, or there is a national security issue and so on. So WhatsApp has a department dedicated to that particular thing, and in those circumstances WhatsApp can release information. Otherwise it cannot release information whenever the government wants. This is a violation of a fundamental right. So that's it about the session from my side. I would like to see your comments in the comment box as to what do you think about the right to privacy in India and what are its implications, and basically where do we stand vis-a-vis the entire world in our right to privacy at this point in time. So that's it from my side. If you like our sessions, please subscribe to our channel and press the bell icon so don't miss any updates from us. Keep liking us and keep following us like this. Thank you so much.